All right, so we've talked in class about how we deal with environmental injustice and infringements in situations like that. A lot of these are resolved through the legal system, and so we're going to talk about that, but we first have to define some legal vocabulary here and talk about how things move through the court systems and what that means. And you might be thinking, well, this is probably why I'm standing out here in front of the courthouse. The truth is that's really just for effect. Although I will say the rain adds a nice brooding element to it. So, all right, let's begin. So this semester, spring of 2024, I mentioned that the Isabella County Courthouse county building had discovered an asbestos problem, and here it is in April of 2024, and they're starting to work on it. So there is the disposal containers, and then there's all the plastic sheeting on there, and that's how that works. That's what it looks like. Be interesting to see how this unfolds. First term is a pollutant. Of course, that's familiar, but a pollutant legally is any waste product. Not just emissions, but solid materials too, and even light and heat pollution. So what's a tort? A tort is a wrongful act or an infringement upon a private entity, something against which a civil lawsuit can be brought. A statute is a law or an act passed by a legislative body. To promulgate something is to put it into effect or to execute it. This law has been promulgated. So an injury is the result of a wrongful act committed against another person or another person's property. It doesn't have to be an actual physical injury. So another concept is called duty of care. What this means is that each of us has a basic responsibility to avoid harming other people.
Hey, Dad, check it out. Should I hit this person?
No, you have a duty of care.
Oh, come on.
All right, so you've hit this bicycle. I don't know where the rider is, but this is an injury, okay? Do you have liability? Well, that depends on whether or not you have committed a breach of duty of care, which I believe you have. So, you ran that stop sign earlier. And that's an omission, because you failed to do something. You failed to follow the law. And that is the cause of this injury, all right? And so that is the actual cause. Actual cause, in fact. Actual cause, in fact, is you failed to stop at the stop sign. Did you just curse on my video?
I'm sorry.
All right.
I can't take this
Okay,
seriously.
hold on.
It's so funny.
So, all right.
You want to run it back, start it again?
No, I don't. I want to keep going. All right.
All right, cool.
So, let's see. And I'm going to say that for this situation, you have strict liability, because it doesn't really matter what your intent was or what your mental state was. Maybe you didn't mean to run over this bicycle, but you are still liable. All right? So, how's your blood alcohol level?
None?
Okay. Well, running the stop sign, we're going to say, was a proximate cause, okay? Because the primary act of injury on this bicycle was you hitting him. Why did you hit him? Because you failed to stop at the stop sign. All right, that's the cause. An injunction is a court order stopping or preventing something from happening. And to enjoin an injunction means to issue it. Like a court, that's something a court would do. Now, the word political is used in the judiciary system, and we're not talking about like red and blue R&D. We're talking about the administration of government and the administration of laws. Res judicata means that once something has been tried, it can't be tried again in a court. And finally, the last term is estoppel. And I don't remember what this is, so I've got to look at it. Oh, yeah. Finally, the last term is estoppel, which means that if you can't make an assertion in court that directly contradicts something that you already asserted.
like the neighbors put in a backyard nuclear reactor. What kind of tort is that?
Well, that would be a nuisance tort. So a nuisance tort is a person who is making an unreasonable, unwarranted, or unlawful use of their own property. So, for example, they're going to create noise and smoke and dust and water and light pollution and thermal pollution and all that.
How'd they get their uranium? That's what all those big trucks were.
That's what all the big trucks were. Now, the big trucks, we could argue, were a public nuisance because they were damaging the roads and interfering with the public's use of the roads. So any damage, any harm they do to us with their nuclear reactor, we could argue is a private nuisance. And we could say, great that you're making electricity, but the harm you're doing outweighs the benefit.
Kind of looks like they're going in a meltdown right now.
Well, that's inconvenient. Here's an example of a nuisance tort. In 2012, a group of plaintiffs sued the Murphy Oil Company, alleging that they had created the conditions of global warming that led to Hurricane Katrina because of emission, thus damaging their property. Well, how did this turn out? The case was dismissed by the Southern District Court of Mississippi because, they said, it presented a political question that required the balancing of, quote, economic, environmental, foreign policy, and national security interests, and is simply non-judicial. They also said the executive and legislative branch of the government are not only in the best position to make those decisions, but are constitutionally empowered to do so. So going closer to home, here's an example of something that didn't become a tort because it was settled before it could get into the court system. In 2020, the Schlegel Sand and Gravel Company wanted to expand its operations in DeWitt, Michigan. And so they proposed opening up another pit near the intersection of Clark and Boychett Roads. So Clark Road is a 2-lane arterial which serves these neighborhoods in here. And the neighbors were not happy about this because they felt that the operation would reduce their property values, that the noise and dust would prevent them from enjoying their property, and that the operation hours of 7 a.m. to 7 p.m. were just, offensive to a normal person. For their part, the Sand and Gravel Company produces construction materials, and sand and gravel are in shorter supply than we would like throughout the world. So the folks in the neighborhood went to their township board and their township officials and said, look, this is the situation. And the township, agreed with them and made the following assertions. They denied the permit on the grounds that there would be an impact on existing land uses, that there would be an impact on property values and along the proposed routes, and that there would be pedestrian and traffic safety issues. And then there would be health and safety and welfare interests. Now that I think about it, this nuclear reactor could also be a trespass tort. And this is, an injury to us as a person and our property and our rights resulting from some unlawful act. It's against the law to put a nuclear reactor in a residential neighborhood.
What tipped you off, the giant tower or the unregulated uranium deposits?
Yes, those are all the things that did that. So we're getting a bunch of material flowing into our yard here. That is a trespass onto our property. It's our possession, and they are interfering with it.
So what can we do?
Well, we're going to sue. We're going to bring civil lawsuit.
I like it.
We could also say this is a trespass to reality, and I don't mean like, reality. It's the legal definition, meaning that this is an unlawful, forcible entry onto our property of pollution. This is our strategy for if we want to seek damage, as in get some money in this pollution control case here. Here's a trespass example. In 1999, a group of plaintiffs sued the Cleveland Cliffs Iron Company, alleging that the Empire Iron Mine in Marquette County, Michigan, trespassed upon their property and their persons because of the dust and the noise and the vibrations of the ground due to mining operations. So, are you ready for this? The court determined that dust particles do not occupy the land upon which they settle in any meaningful sense. They simply become part of the ambient circumstances of that space. They also said that physical, tangible objects must be more substantial than gas, dust, or fume.
But dust is physical.
I know. And that wind and water are invading agents, but not dust.
What about negligence?
Well, to bring a negligence tort, there has to be an existing duty of care. Like, for example, you're obligated to not harm the water supply, for example. There has to be an act of omission against that duty of care. And there has to be a resulting injury that's recognized by law. Then you have to be able to figure out causation, whether it's actual in fact or proximal. And so negligent torts also require proof of fault. Now here's the thing about fault. The polluter could say, well, look, I've done everything according to accepted standards and regulations.
So polluters are not negligent even though they're polluting?
Yeah, could be. Listen, if you want more, check out Juergensmeyer, Control of Air Pollution Through the Assertion of Private Rights, 1967, Duke LJ 1126. He's gone. In 2010, the Mosaic Fertilizer Company maintained a wastewater storage pond in Tampa Bay, Florida. The state had previously warned the company that that pond was close to exceeding the safe storage level. And in fact, furthermore, they said the dike that you have that is holding the pond in is 3 feet narrower than what we require by law. It's supposed to be 18 feet. And then the state determined that 1 or 2 inches of rainfall would cause a breach. Now this is Florida where it rains a lot. Hurricane Francis rolled through in 2004 and the dike failed. So all of those pollutants were released into Tampa Bay. So the fishermen who make their living fishing the Tampa Bay sued under negligence. And the lower court that they went to ruled that the fishermen had a case and they could proceed with their negligence claim. But the Mosaic Fertilizer Company appealed that to the Florida Supreme Court, and it was reversed on the grounds that the fishermen failed to state a cause. A cause of what? Well, it turns out that a negligence claim requires proof of conduct by the defendant, Mosaic Fertilizer, causing actual loss of damage. Now, the court did not come to a firm conclusion that the release of pollutants into the water violated the property rights of the fishermen, and therefore they were somehow negligent. The takeaway here is that negligence claims are very hard to settle in your favor. Now, Mosaic did give a settlement because they wanted to make this problem go away because the appeals process was still ongoing. Well, what are the possible outcomes of environmental torts? A lot of the time, nothing. Sometimes injunctions are enjoined and action is stopped. Sometimes we see widespread publicity a lot of the times, and that has its own effect on resolving issues or at least addressing them in the public sphere. Permits can be revoked or in some cases granted. There might be monetary penalties, in other words, a fine or a fee is assessed. Not very often is there jail time, although that's not really impossible. A lot of times there's an administrative penalty where a process is specified by a court order to remedy, rectify, or maybe redo a situation. So next time we're going to talk more specifically about courts and how they work and what they've done with environmental law through time. See you then.